Testing, yeah, it's working. I don't know what.
Oh, that's weird. Carry on.
Testing, oh, now it's working.
Okay, good.
Yeah. Good. Go out in the meeting room.
Reasonable.
Hi, welcome everyone. I am Professor Alex Roberts. I want to thank today, as we get started, Nasser Eladrous, Natalia Pfeffer, and Deb Feldman for help planning and executing this week. And thanks to those of you who are joining us in person and on Zoom. I know this is not just a regular busy week, but like probably the busiest week of the semester, if not the whole year. So I'm really pleased that some people came out for our discussion. So I also want to introduce my featured guest, Rebecca Tushnet. She is Frank Stanton Professor of the First Amendment at Harvard Law School. Her scholarship focuses on copyright, trademark, and false advertising law. So if you know me, you know that those are all of my favorite things. She has degrees from Harvard and Yale. She clerked for Judge Becker on the Third Circuit and Justice Souter at the Supreme Court. And of particular relevance for today, Professor Tushnet has authored both scholarship and an amicus brief discussing this case. And the brief focuses specifically on the constitutional issues in play. So my plan today is to give you an overview of the facts and litigation up to this point, and then I want to put some questions to Professor Tushnet, and then we'll open it up to questions from the in-person and the Zoom audience. Okay, and you can see I have lots of props today, so you can see things on the screen and live in person. So VIP v. Jack Daniels, what happened here? Jack Daniels is a well-known whiskey brand, right? It has trademark protection for not just its brand name, but also its trade dress. I bought this on my way into work today. Unfortunately, I was not carded. I confess it hurt my feelings a little bit. So the whole kind of like configuration of the product, right? The shape of the bottle, the colors, the label, all that kind of stuff put together, trade dress protection for that. And then VIP makes these silly squeakers line of dog toys that kind of pun on well-known brands. In particular, they seem to do a lot of beverage brands. So some alcoholic ones, some non-alcoholic ones. There are a lot of products like this. If you're a dog owner or a dog lover and you've been inside a store that sells dog toys, this is a really common business model, right? We see like shelves and shelves of these. Some of them are very clever and entertaining. Some of them take you a minute. Some of them are more funny and some of them are less funny, right? But this is, VIP is not the only company doing this. So actually I have a few more. I took this last spring in a store I walked into. I got really excited. We also have a whole lot of handbags, right? Other kinds of products too, but plenty of like food and drink related ones and plenty of kind of like luxury items, particularly handbags. I'll maybe come back to these, but this is not the first parody dog toy to be involved in trademark litigation by a long shot. So there are a lot of these parody items and they have been litigated before with varying results. So we don't always get the same results in these cases, although I think we do often see that they're treated as successful parody. So VIP Products sells this, right? Bad Spaniels Silly Squeaker dog toy, which looks like Jack Daniels Old No. 7 Black Label Tennessee whiskey, but instead of those words, it says Bad Spaniels. Old No. 7 is replaced with Old No. 2. The alcohol content description says 43% poo by volume, which for some reason the Supreme Court justices didn't like the word poo and they prefer the word excrement. And I was like, I don't really know if that's better and more sanitized, but I guess whatever you're comfortable with. So there's a tag also affixed here. It says the product is not affiliated with Jack Daniel Distillery. So Jack Daniel sends a cease and desist letter to VIP, right? We think your product is infringing and diluting. VIP says, we think it's not. So we're going to seek declaratory judgment that it's neither infringing nor diluting. So quick review, I think the people in the room mostly know this, right? But so for infringement, we're asking, does the use create a likelihood of confusion, either that the actual source of the product is Jack Daniels, or it could just be that it's sponsored, that it's endorsed, affiliated, that it's made with permission, that it's made with a license, that it's authorized, any of those kinds of things, right? And in this case, Jack Daniels showed up with survey evidence. So they brought in a well-respected kind of expert who ran a survey, had found that 29% of respondents thought that the Bad Spaniels toy was made, sponsored, or approved by Jack Daniels. Maybe a little surprising. Maybe you wouldn't have responded to the survey that way yourself, but maybe not. So it didn't go that well for VIP at the district court, right? Of course, Jack Daniels had counterclaims that it was infringing and diluting. Oh, I didn't get to my dilution slide. Okay, so Jack Daniels says it's going to create a likelihood of confusion. And by the way, it's also tarnishing. So the allegation here is dilution by tarnishment, right? So first we want to prove that the Jack Daniels marks, the word mark or the trade dress or both are actually famous among the whole general consuming public in the United States. And then second, that the use harms the reputation of the famous mark. So in other words, because it talks about poop, or because it's just a dog toy, or it's kind of a low quality, low price point kind of product, for one of those reasons, it harms the reputation of Jack Daniels, whether or not people are confused, right? And the district court says, yeah, we think you're right, actually, and your survey evidence is really persuasive. So we're going to enjoin the manufacture and sale of this toy. So VIP appeals to the Ninth Circuit, and the Ninth Circuit says, no, they weren't right. You were right all along, right? This is a parody. Oh, we love parody in trademark law. That's so fun. It makes everybody laugh, right? So what is parody? We have to start there. Appropriating somebody else's mark as an element of popular culture and then building on it for humorous effect or for commentary, for criticism, something like that. And we actually get some really helpful language out of another dog toy case, which of course, I have this one too. So the court in this case said a parody has to convey two simultaneous and contradictory messages at the same time, right? That something is the original, but also that it's not really the original, it's a parody of the original. And the second message has to differentiate the parody from the original, communicate some articulable element of satire or humor or commentary. It's got to make a joke in a way that you can actually explain and articulate, right? So you need an original host work. That host work has to be famous or well-known. The creator of the derivative work has to use only so much of the host work as is reasonably necessary to do a successful parody. And then the derivative work that conjures up the original host work has to result in a new original work. So that's kind of how we have thought about parody, although really every circuit thinks about it in a slightly different way, right? So they acknowledge there's a need to take into account the First Amendment concerns, to balance the speech concerns on the one hand against the concerns about consumer confusion and competition and even harm to the brand on the other hand. And there are a few different ways to do that. But some circuits and increasingly more circuits have used this test, the Rogers test. So the Rogers test started out as a test for titles of things, like a title of a film, Fred and Ginger, for a movie about Fred Astaire and Ginger Rogers impersonators, right? Empire as the title of a TV show about a record label called Empire and a family that's fighting for control of it, right? Stuff like that. But more and more courts are using it for other kinds of expressive uses, artistic uses, hybrid commercial and expressive uses, to get to the bottom of this question of whether the use is allowable. So we're trying to make more space for these First Amendment concerns. So this test says, even if an artistic work's use of a trademark would otherwise violate the Lanham Act, it would otherwise constitute infringement, it won't, unless the use has no artistic relevance to the underlying work whatsoever, just no relationship to that artistic expressive work, or if it has some artistic relevance, unless it explicitly misleads as to the source or content of the work. So we've really moved the bar, right? It's not about some possibility of likelihood of confusion. It's about just artistic relevance. So you can see there's like a lot of open questions here, right? Like, is a parody dog chew toy that makes a poop joke, is that on the same level as? Is that something we should treat the same way as a film, a song, a TV show, all that kind of stuff? So what is the message? This is at least the message that VIP claims to be making. A humorous message based on wordplay. Oh no, I lost it. That's not the language I wanted. Here we go. Reflecting on the humanization of dogs in our lives, right? What's the joke, VIP? Well, it's funny that we love our dogs so much and we treat them like people, and you want to have a Frappuccino and you also want to get a Barcacino for your dog or whatever that dog toy is called. You want to have a Chanel bag, you want your dog to have a Chanel bag, chew toy. That's so funny. Specifically here, you want to drink your Jack Daniels, you want to give your dog your bad Spaniels so you can be twinsies because you love your dog that much, right? Also, a comment on corporations that take themselves very seriously. All these companies that spend all this money on advertising and their trade dress and investing in their reputation, they take themselves too seriously. So the joke or the commentary or the critique is about that idea, to kind of mix it up a little bit and make people laugh. So this case, right, cutting to the end, is on appeal before the Supreme Court. We had oral arguments in March, and we should get a decision, I think, by June, by the end of the term. And Jack Daniels raises two issues: whether humorous use of the trademark on a commercial product entitles VIP to heighten First Amendment protection on that infringement claim, right? So do we treat it like a regular infringement claim? Do we put it to the traditional likelihood of confusion test using the factors in the jurisdiction that we're in? Or do we give it a special kind of treatment the way we do with books and movies and things like that, right? Traditional works of art, expressive works. And then whether humorous use of the trademark is a non-commercial use that can't be subject to a tarnishment claim. So I know I had that slide in here somewhere. So there's a nice, robust carve out in the statute when it comes to dilution by blurring, dilution by tarnishment, that use of a famous mark by somebody else, if it's in connection with identifying and parodying or criticizing or commenting on the famous mark owner, or the goods or services of the famous mark owner, that's going to be barred from a dilution claim. So that's where we are. That was just getting everybody up to speed. And I want to ask Professor Tushnat some questions. Are you ready?
Yes.
Cool. All right. Intuitively, I think it feels easy and straightforward to grant a lot of leeway to traditional artistic works like I was talking about, right? Like films, songs, novels, plays, all that stuff. In contrast with traditional branded goods like toothpaste or cars. And the case law says Rogers is the right test when artistic expression is at issue. But now we're talking about mass-produced commercial goods that contain some speech or some message, like a humorous greeting card that says, "Honey Badger don't give a shit," or dog chew toys, or t-shirts with puns, things like that. It's a little confusing. So the Ninth Circuit in this case said, it doesn't need to be Mona Lisa, it doesn't need to be Anna Karenina. We analyze whether the work is communicating ideas or expressing points of view. How can trademark law properly understand this middle category of stuff? How do we know when something contains speech or conveys a message or doesn't?
So let me do the things that law students need to know how to do in the right circumstances, which is say the premise of the question is wrong, right? Or unless we invent a new rule for trademark, there is no such thing as a middle category. There's either expression or there's stuff that isn't expressive. And we can, in fact, invent a rule that is special to trademark that would go against the current First Amendment jurisprudence of the last, 60 years or so. And if we do it, we should know why we're doing it. But if you take the non-trademark framework, there's commercial speech and there's non-commercial speech. And just to drive the point home, like the New York Times is mass produced, right? DVDs are mass produced, video games are mass produced, and movies are mass produced. And of course, all of these actually went through a history where courts would treat them as, completely regulable, right? The government could do whatever it wanted. And then we started to realize, you know what, that's probably a bad idea. So radio, movies, video games all had their moment where courts said, you know what, although this isn't a conventional at the time way of expressing things, it very much is expression. And so it gets First Amendment protection. So the line the court has drawn in other areas is between commercial and non-commercial speech. And commercial doesn't mean sold. That's the key thing. New York Times is sold, right? Avatar, the movie is sold, songs are sold or rented or, accessed for money or through or by being advertising supported. You can try and make money with your art. That's totally okay. So commercial speech is speech that does no more than propose a commercial transaction. So essentially an ad, although it doesn't have to be in a conventional ad format. So one way to understand this is like the Diet Coke that I love so dearly is in a can, right? And the Coke markers on the cans are not what I'm consuming. They tell me what it is I want to consume. So they do actually serve an advertising function. And so, classic product labels certainly fall comfortably within the idea of commercial speech. It's speech, but it's directed at telling you what's on the inside of the can, right? The Bad Spaniels dog toy is not that. And at oral argument, it was fairly clear that the court understood that there were at least some circumstances in which the fact that the speech is integrated with a product that has another function can't be dispositive of the constitutional question. And this is because the Supreme Court has faced numerous challenges where people have written stuff on shirts. And if it were the case that the fact that the shirt has the function of covering the human body were enough to take it outside the First Amendment, we would just say, sure, this guy Cohen can be sent to jail because instead of holding up a sign that said, fuck the draft, he had fuck the draft written on his jacket. But they were punishing him for the speech, right? And so when the regulation is directed to the speech and not like, oh, that jacket is made of hazardous materials and it might burst into flame, then we apply First Amendment analysis. So I think the court was concerned, certainly, about the fact that a dog toy is not a traditional medium of expression, but they were also quite aware that tradition isn't the only driver here. The question is, in many ways, what's the social meaning? Right. So are people getting messages out of this? And so this is kind of the key underlying question. My brief argued from the current jurisprudence that you should, maintain this commercial, non-commercial line and apply a more rigorous test to speech that's non-commercial. And in fact, very rarely allow for trademark liability for non-commercial speech. If the court doesn't do this, and clearly there was some interest in trying to find a way around this, they will have to explain what makes a shirt different from a dog toy. And I wanted to, Professor Roberts had some really interesting points in the course of the litigation. I just wanted to point out that surveys showing high levels of consumer confusion about speech are extremely common. So my favorite is a case that Walmart brought against this guy who didn't like Walmart. And as part of his not liking Walmart, he produced these T-shirts that had on the front, they had an image, and the most prominent thing in the image was either Holocaust or Wal-Qaeda. And then there were other things like in the image, like a statue of Stalin and the dime store from hell and a little version of the Scream icon. This was not a pro-Walmart shirt, is the point. And Walmart produced a survey, I think by the same guy, actually, showing that over 47% of consumers were confused about whether Walmart was the source of or affiliated with the Wal-Qaeda and Holocaust t-shirts. So part of this is that surveys are manipulable. Part of this is that in an expression case, you're often asking the survey respondent, do you think the law requires permission? Even if you formulate it as, do you think they got permission? Functionally, right, when you're asking people to say, okay, well, do I think this needed permission? And if I do, then yeah, I should ask, yeah, I think they probably got it because there it is. So you're asking them ultimately about their opinion of the law, which is different than if you ask, like, you know, is the Coca-Cola company responsible for producing this can? And then finally, and highly related to that, is that modern trademark law generally doesn't require that any confusion be material, that it affect a purchasing decision. And we know people aren't careful when they don't care. So because the current test disregards materiality, people are automatically, inherently more likely to be guessing in their answers about this. So for all these reasons, a test that purports to be empirical and relies on survey evidence is going to be likely to be wrong precisely at the point at which people are making stuff that has a message about the trademark owner, even if the message is, you know, don't take this very seriously. That was a long answer.
No, that was a great answer. And I wanted to ask you a follow-up question about surveys, because you made a lot of great points about the role of the survey here and in cases like the Walmart case. So I wonder if this tells us something about the survey tool itself, or does it prove that surveys are less useful or maybe not useful at all in cases involving speech? In an era of like collabs and crossovers, we talk about this a lot, you know, where the kinds of crossovers and endorsements that we wouldn't have seen a couple of decades ago have become really commonplace. Have those collabs and crossovers kind of trained consumers to find confusion everywhere, right? So, okay, go the band, and you put it on some instant cereal, and the band says, well, everyone is going to think that this is a reference to us, even though we're in totally different areas. We make music and you sell cereal, because everything's a crossover, everything's a partnership. So you've retrained consumers to expect that. So that's what the survey is always going to show. So I guess boiling that down, what are the takeaways for surveys in speech cases? And then for surveys more broadly, are they still as useful as we expect them to be?
Yeah, so I don't actually want to defend surveys in sort of non-expressive in commercial use cases, because I think they have a lot of weaknesses in general. And it's notable that the United States is an outlier in actually its use of survey evidence. In many other countries, judges tend to say, you know, we are looking for real marketplace evidence, and a survey is both inherently artificial and likely to be subtly tweaked in ways that don't reflect the actual experience. And there's actually a point here which is about sort of error costs, right? So this is a general problem. You know, you could try and have a perfect procedure that puts in absolutely as much evidence as possible, right? You know, you devote $2 million to litigating every case. And probably you would marginally increase the accuracy of the results. That'd be bad for society overall, right? And you know, there are various ways we handle this. So in criminal cases, we have the beyond a reasonable doubt standard, which is designed to implement the idea that we'd rather have a bunch of false negatives than really any false positives. But in civil litigation, one way to do that and to make it possible to litigate valid claims and also get rid of invalid claims is to have, you know, a standard that you can apply without conducting too much of fact finding. So especially if we believe that consumers are sort of have predictable characteristics that follow them across at least some areas of their lives, we can do things like look at the mark, right? And look at the defendant's mark, look at the products. And it is true that the co-branding and so on does complicate things, but it's not clear that surveys make that any better. It's also probably the case that courts are really have really misinterpreted the kind of rise of co-branding. So think about like when you encounter, if Fenty collaborates with Chanel, it's going to say Fenty or Rihanna X Chanel, like as big as possible, because that's the whole point. They aren't going to be subtle about it. And so the idea that that is the same thing as like a co-branding thing with a dog toy is just a mistake about the kind of level of generality that we're talking about. So if we wanted to be more empirical, we would actually look at what does co-branding actually look like, and what have consumers to learn to expect from co-branding. And that would be probably a more reliable empirical question than surveys. And certainly like the general problems of surveys are clearly, enhanced in the speech context, in part because of the lack of materiality.
So I don't know if you teach parody this way. When I teach parody, I tell students about the cat not in the hat test. So this kind of idea that's come up in a lot of cases, that there's a way to do a successful parody, just kind of the way the Chouet Vuitton court outlines it. You're using you're simultaneously communicating it's the thing and not the thing. You've got a parodic or a satirical or a humorous message about the thing or about the culture surrounding that thing. With Chouet Vuitton, it was like conspicuous consumption and really high-end exclusive handbags and things like that. And that there are also parodies that fail. So if you use Dr. Seuss's trademarks to say things about O.J. Simpson, that's not a successful parody under trademark law. So you don't get to avail yourself of that defense. So I'm just wondering right now, where as everything stands, is this a useful distinction? Is it helpful for the categories of goods and speech at issue before the Supreme Court? Or is this a test that kind of asks judges and juries to evaluate a joke, to decide whether it succeeds or fails, or decide whether it's coherent? And that's a problem when all we really should be asking is there expression here or is there not expression here?
Yeah, so look, I always like talking about different ways of teaching things because it gives you great insight into the different ways of seeing. So I teach it a little differently. So the idea that I have is that when you hear claims like a successful parody communicates two things simultaneously, both that it's the original and that it's not, what you're hearing is a normative judgment framed as an empirical assertion. Because does the judge know that the two messages happen simultaneously? Right? The judge has, and what would it even mean for things to happen simultaneously? Right? And why would simultaneity matter? Right? To the question of whether people were confused in some actionable way. And indeed, in the related area of initial interest confusion, we've had courts start to realize, oh, wait a second, like it can't be the case that even a momentary like uncertainty is actionable given all the other reasons that people have for using trademarks comparatively or making references or, inviting people to shop related goods or whatever. So I've always thought that the claim about parody is made so that you can have your cake and eat it too. Like, we're protecting free speech, but don't worry, it doesn't have any costs or not any real costs. And that might well be true, but it's probably worth talking about, which is driving this. Is it really that it doesn't have any costs, or that the costs are worth bearing, at least when the confusion isn't all that bad, and when there's a benefit, right? I think you don't always have to do the cost benefit analysis out in the open, but it's really useful if you understand that that's what you're doing. So I would say, like, and you can see this in the outcomes, right? So, the judges on the Fourth Circuit say, well, we think it's funny. We didn't have any trouble. So, it must be working. But that's just, unless you are clear about what's driving that, that's just a recipe for holding liable just the people you don't like, right? And that, I think that's sort of fundamentally anti-law in my view.
Doesn't applying the Rogers test to these mass-produced commercial goods like chew toys, greeting cards, create a slippery slope, in the words of Attorney Blatt? So as long as products claim to make a joke or make fun of a brand or a segment of consumers or society at large or anybody who takes themselves seriously or some message, they can copy any trademark they want with impunity, even if it creates confusion. So if a slogan in a greeting card is an expressive work and a dog chew toy with a punny label is an expressive work, what isn't an expressive work? You know, is anything that contains text or anything that contains logos or has a full sentence within it, is it all expressive?
And so again, like, it's not like we're writing on a blank slate here, right? The commercial, non-commercial speech distinction has existed for a while. There have been a bunch of edge cases. There will continue to be a bunch of edge cases. So it's not, so I'm not contending that this is, you know, some magic bullet, but it's the best one that we've come up with so far. And there's lots of case law to guide us on it. So, and all Blatt's parade of horribles, my reaction was, you know, this is basically a parade, right? So her parade of horribles was, you know, if you don't rule for Jack Daniels, people could make decorative pillows shaped like goldfish. Okay, I mean, that sounds fine to me. I actually own one. It's cute. It does look like a goldfish. Nobody's ever tried to eat it. You know, it's. The question is really, what kind of communicative environment are we going to live in? And frankly, I'm happy to live in one where, you know, there's a sort of play of meaning. That, you know, the world of Etsy is a perfectly nice world, it seems to me.
So we've mentioned oral arguments a couple of times. I wanted to just hear any other impressions that you have, highlights, lowlights, best, worst, messiest moments, and whether you think the justices have a firm handle on the legal doctrines and on the stakes in this case.
Yeah. So, well, okay, let me, I can start with at least a controversial opinion, which is that the rise of the specialized Supreme Court bar has not been great for law in general. Now, of course, Supreme Court justices are, by virtue of their own backgrounds, going to have particular experience in particular areas, right? And so they won't, you know, be masters of all the fields of law that they're asked to encounter. So this is an inherent problem in having a general Supreme Court, and it is definitely, it's probably a problem, you know, worth sustaining. It's like specialized courts don't seem to be, you know, better. They just have different problems. But what it means is when the advocates are directing themselves at, you know, convincing 5 justices, right, through careful study of the arguments that are, you know, work in general for, you know, you have to patch together 5 justices. They aren't as good at explaining how the moving parts of the system will be affected by the one intervention the Supreme Court has been asked to make. And so I think it overall somewhat degrades the court's capacity to really, you know, I mean, it's not like they're going to be modest anyway, but I think they're not modest in ways that are even less sensitive to how an overall system will be affected by an intervention on one legal rule, which is in general what they're, you know, of course, what they're being asked to do. So, so I think it then tends to lead to advocates who sometimes make misstatements about the law, which I don't think are necessarily intentional. But like at oral argument, Lisa Blatt said, you know, for example, Gone with the Wind isn't a trademark. Like, it isn't? Because, you know, it turns out the Mitchell estate has a perfectly working registration for books and, you know, other media, which I suspect is actually a valid registration. And so it's these assertions, and I think it's particularly difficult in a case like this, where there are all these claims about, like, well, of course, like, this is confusing and confusion is bad, right? It's a very sort of surface level understanding of the different types of confusion that courts have recognized. So especially, Jack Daniels is playing on your mental model of counterfeiting, right? So counterfeiting is just a different thing than what's at issue here. But if you think, oh, confusion is like counterfeiting, you're going to reach different conclusions than if you realize, over the past 80 years, courts have expanded liability under the Lanham Act to basically reminding you of something else. And, that raises different issues. So, so that's my screed against, how things have shaken out. I will mention one thing that I thought was quite interesting at oral argument and is in line with the idea of criticizing surveys, which was that Justice Alito seemed interested in exploring the idea of using a normative concept of the reasonable consumer. So he was basically saying, like, couldn't we notice that, a reasonable person would not be fooled by this? And this would be in line with a number of trends in American trademark law. It's just that we don't tend to identify when we're doing normative versus empirical. It would also actually move us towards the international consensus, which is more about a sort of objective, reasonable consumer standard. And reasonable doesn't mean smart or very sophisticated. It just means sort of something other than completely gullible. So that's, and I think that would be quite interesting, and actually it could have big effects, well beyond the parody or expressive use situations.
All right, this is my last question, then I want to open it up to the audience. So we've really focused, I think, on the stakes for trademark law, and I'm wondering if you can say a little bit about the stakes when it comes to constitutional law and First Amendment doctrine with this case.
Yeah, so, I mean, look, consistency is the hobgoblin of small minds, right? So it's unreasonable to ask a system for perfect consistency. At the same time, especially in the area of free speech, being able to give reasons and situate cases in an understandable matrix is really important, so that you don't just punish the speech of people you don't like and free the speech of people you do like. So, so this is why my brief focused on the commercial versus non-commercial divide. If we want to do something else, I don't think that would make us not a democracy anymore, right? But I think we need to think carefully and systemically. So if we say the rule for trademark is, books and movies are special, and video games too, fine, they're well recognized enough, and shirts, right? But dog toys are just a bridge too far. Then let's set forth the principles that will let you know, okay, so, what about, I don't know, an Apple Watch, right? What is that, right? And help us figure out what objects are going to fall within your new category and what aren't. And it would be possible, right? It's just, it would just be a big move that could easily destabilize stuff. Or you could just say, we're just going to have a special rule for trademark, right? And again, I think you can do that, but it would be very useful to figure out why, because maybe then we should have a special rule for, something else, right? And defamation, of course, is the obvious sort of elephant in the room, because it's another private cause of action. It also deals with reputation. We have a lot of constitutional doctrine that's built up around it. Why, right? Why do we care? And, there is a strong historical answer. It's been used to suppress the speech of people that, powerful people and juries didn't like. Historically, that hasn't turned out super well. And, I think we should just think about, especially if we're going to have special rules for private causes of action, how do we think they fit into the overall system?
Yeah, hold on.
So I'm unsure if this question was summarized earlier throughout the presentation, but it's been on my mind because we talked about how if you walk into a pet store, you'll see many brands like also having the same parody. And then you touched upon a lot about how surveys can be easily manipulated, and so they shouldn't be reliable. So I guess as a basic question, like, what is the benefit for Jack Daniels for bringing this case? Like, if they were to prevail, like, what is like something that they can easily gain that makes it worth it to go through all of these, like, to go through this entire process? Because I'm just not really, I'm not seeing it just yet.
So obviously this is, I'm not pro Jack Daniels. So you're going to get my version of this. So first of all, we often have this assumption that consumers are irrational, but businesses are totally rational. This is false, right? Consumers are good at certain things and bad at others. Businesses are good at certain things and bad at others. And especially at the executive level, right? They are super invested in the brand. They live it, they are true believers. This is a travesty, right? This is like, not only is somebody insulting them, they're making money off of doing it. It is a profoundly felt moral injury. And like, that's real, right? It's a real feel, like, you know, I don't think we should honor it, but it is 100% real to feel that way. And so one of the answers is they feel it as a personal insult, right? And also, right, they think, like, they also want to teach people not to mess with Jack Daniels, right? So you know, if a bunch of people look at this and say, you know what, I'll parody something else, right? That's a win for them. So and they really feel like, oh, you know, people could respect our brand less, right? Regardless of the empirics.
Yeah, I think you covered just about everything. So I would add, in addition to those kinds of perceived harms that are alleged, just this overall sense of control, right? We are in charge of our own brand. We manage our own reputation. You did this without our consent. You took us by surprise. We don't like it. We want to have a say over the parameters of, you know, the brand's personality and the way that the brand appears and all that kinds of stuff. And as Rebecca said, there's this kind of signaling that happens with policing that we're a brand that you shouldn't mess with. We will not be afraid to send a cease and desist letter, to sue you, all that kinds of stuff. We might one day want to make our own dog toys. That came up in the butt wiper case. So Budweiser sued VIP over the butt wiper toy, right? And they said, listen, we sell dog stuff too. So we are already in that market and we want to be in charge of that market. Lastly, without insulting my own, I gotta say we have a problem sometimes with trademark lawyers finding billable things to do, right? Saying to the brand, or, you know, if you're in-house, or saying to the firm, hey, here's something I noticed. We don't have to do anything, but here are the things we could do. You know, we could write this letter, we could bring this suit, we could come after them, and we know exactly how to do it, and we're ready to go. So if you say the word, you know, you can just sick us. Because I call out Monster a lot, some of these brands that are really famous for bullying, and sometimes that's what it feels like, right? Like trademark lawyers maybe focus on something else instead of coming after every single thing that pops up where you see the word monster.
Yeah.
Thank you.
Thank you. I just want to say thank you for coming today and sharing your knowledge with us. So my question is, if the court were to throw out the Rogers test, what do you think the impact would be on parodic works and artistic expression works and their ability to be able to protect themselves from trademark infringement lawsuits?
Yeah, what a great question. Thank you. So the Solicitor General took the position that you should throw out Rogers, but don't worry, they promised. Real parodies will survive the multi-factor confusion inquiry because you know, of the logic that we already discussed, that you know, a real parody, you know, won't be confusing. And so I do think that some parody courts who liked the parodist would tend to think yeah, you're right. It's still not confusing. But you would see others, enjoined. You would see more, movies enjoined, more songs, not all though, right? And part of this is actually about doctrinal hydraulics. This is that when you increase like the scope of a right or of a defense, things happen in response. People, figure out workarounds. So we might also see greater deployment of things like nominative fair use, even descriptive fair use, trademark use as a mark, which is, very much deprecated in most circuits now. But you would start to find more people saying, well, I just don't think this is a real trademark use, right? As a way of explaining their conclusions. So it would not, I think it would be bad. It would also mean that it would be very hard to get things dismissed on a motion to dismiss. So the people who won their defenses would be richer on average than the people who do so now. That's my prediction.
So given the quality of the student questions, I'm the person who knows least about this subject area in the room. So please bear with me. So I'm Brooke Baker. I'm a faculty member, but don't know as I said, virtually anything about this. But my question is, how much do you think in the real world this really turned on the disparagement, the kind of hostile, even cruel subject matter here? To talk about poo in particular, would it have been different if it was piss? Maybe only a little bit. But we could think of it as having had something cute instead, right? Something cute and funny. So the concept of parody covers everything from cute and funny to highly disparaging and critical and even cruel. And the commercial motivation here seems to me, if I were thinking, it's much more what you were talking about, which is you're tarnishing my brand. You are making fun of this thing that is very important to us. And that's what we object to. And as you said, yeah, and plus you're making money off of it. Do this for, some insignificant Kentucky branded bourbon and no one would do anything, right? So I guess, and I didn't hear quite as much about the disparagement piece of this and of the analysis and how you think that the court is influenced by that, because that's where the emotional reaction comes, I think, certainly from the brand owner, but also even by reviewers, by, and maybe commentators to some extent.
So honestly, I think the reason you don't hear more about this is that it is the part of the analysis that's self-evidently defiant of the larger free speech tradition, where, for decades, the Supreme Court has said, the right to be vicious is actually a fundamental part because it's the most likely to be political. Right. And to have a larger political message. So you can be vicious about Jerry Falwell, who, by the way, has protectable trademark interests because he's was a well-known preacher. Right. The Falwell name does have trademark meaning, but you have the right to, to criticize him by mockingly suggesting that he had sex with a chicken and his mother. Right. And those are and so that's offensive, right? It's, it's quite arguably unfair. But because of that, right, it gets stepped up protection because we expect that kind of sort of freewheeling, elbows flying discourse when we're talking about public figures. And Jack Daniels is by any measure a public figure. Precisely because it's well known. So I completely understand that intuition. I think the Europeans are very much feel that way, but that's because they don't have this tradition of recognizing unfairness as actually kind of central to political speech, at least when political speech is, sued over.
So the court just won't expressly pay attention to
it? It might. I mean, it's very hard to tell. So yeah, I mean, there's also this sort of weird, as Alex noted, prurience, right? So in the previous trademark constitutionality cases, they had a guy who wanted to register. It was FKUC or no, maybe FFC. FUCT, and they would not say fuck, right? Like, and they would not say, and they wouldn't even say the phrase the N word, right? There were references to a particularly like disruptive phrase that that we're worried about, and which is sort of two levels of like, so and the Jack Daniels was very clearly leaning into the idea of imposing public morality, and clearly there are a bunch of recently appointed judges who would be interested in that. It's not clear that the Supreme Court judges are open to that, but this will be one way that we find out.
I think, when we're talking about the intersection of constitutional issues and trademark law, we can at least find important interests when it comes to preventing confusion and preventing deception and ensuring that trademarks aren't being used to lead people astray, and particularly when those deceptions are material to a purchasing decision, right? That feels straightforward and easy to identify that interest. And I think on the other hand, there's a lot of skepticism to the idea that there's some important interest in protecting the ability of only famous brands, right? Only these trademarks that are famous among the entire country, men, women, children, all dog owners, drinkers, everybody. So only they get the protection. And then they get the protection when it's so hard to figure out what the measurable harm even is, right? So for blurring, it's supposed to be that it whittles away at the distinctiveness somehow. And for tarnishment, it's supposed to be that it harms the reputation. But there are a million other ways that people can harm your brand's reputation all the time that are fully protected by the First Amendment and that the brand can't control. So I see the argument, and particularly the argument about why does Jack Daniels care when all these other brands are so tolerant? Well, a lot of those other brands are on the receiving end of jokes that are cute and cuddly and inoffensive, and just a couple of them maybe are on the receiving end of jokes that involve toilet humor or make people associate your brand with these things that are really gross and icky. But at the same time, it's hard to even, I think, make peace with that in the face of the First Amendment limitations. Yeah. Oh, a lot of questions.
Any insight on how?
Yeah. Any insight on how the newer justices may vote?
I don't make predictions. I mean, for all the reasons, like we're clearly in a period where, there are people willing to throw out a bunch of prior law. And so they're going to do what they're going to do. In some ways, because this isn't super partisan, it's much harder to predict. So none of these people were hired for their opinions on intellectual property. And in some ways, because of that, their kind of underlying theories of the world may be very different. They just happen to have consensus on some other things. So I don't think it's clear at all. I think the Jack Daniels strategy was very clearly like, let's go after Rogers in its entirety and convince the court to compromise by saying, well, Rogers itself is probably okay, but, and we won't decide today on that, but just not for the dog toy, which goes into a win in Jack Daniels' corner and just makes things harder for everybody else, to figure out what happens next. So yeah, that's why I'm not predicting.
Okay, I think we have about 3 more questions. So this is John Lee. Do you think that part of the issue more fundamentally is with the theory of sponsorship or affiliation confusion? That theory seems to expand considerably the breadth of infringement versus just limiting it to source confusion.
Right, 100%, right? And this is where the mistakes about the law start to really bite. So that I have, two suggestions for that. I say them a lot because I think they're relevant. So one is materiality. So a lot of times sponsorship is just not material to consumers, and we should care about that fact. And then the second is, courts should actually be much more careful about what they think sponsorship means as a legal term. And that's why I give the, Rihanna X Chanel kind of example, because if we looked at real official sponsorships and said, things should look like that before they cause actionable confusion, even without materiality, you would actually get a rule that was not completely unfixed and completely encouraging trademark owners to try and convince people, oh yeah, permission is required for everything.
Okay, from Lisa Ramsey. Do you think the Supreme Court might adopt a trademark use requirement or commercial use requirement for liability instead of adopting the Rogers test? Some justices seem inclined to support a focus on whether the use was source identifying or whether it was a political message. Also, they didn't like the artistic relevance prong of the test. So you talked about this a little before as a potential consequence, but could it happen in this specific case?
Yeah. So I think there's some chance that they will just assert that certain things are not source identifying. And how that happens could make a big difference in what happens next, because in lower courts, the basic trend has been to say, if something confuses about source or sponsorship, then by definition, it is source identifying, because if it weren't source identifying, it wouldn't be confusing. And this has a lot of logic to it, except if you notice that sort of special quick move, source or sponsorship, oh, it indicates source, right? So depending on how it got said, this could do a lot of good work, or it could do something that was easy to disregard by saying, oh, well, it's confusing. That means the source indication requirement has been satisfied. And I do think they showed some interest in that, but I'm not sure that they kind of understood how it would need to be written to actually provide protection for speakers.
Okay, this is Felicia Caponegri. Do brands, especially iconic or heritage brands, have a responsibility to allow parodies or other commentary on their marks?
And this is the American in me. I'm not sure that it's that talking about it in responsibility terms changes much, right? Because the question is, so what is it fair in terms of a system of free expression for other people to be able to do? What are the fair hits, right? Like, you think I'm a terrible professor. Okay, like I don't like it, but I accept you have the right to think that and even to tell people, right? So it's very hard to put responsibilities into American legal language. And we could do that, right? But I think it would require this kind of broader rethinking of what it is that we're doing with our system of free expression.
All right, I think that's it. So thank you so much, Rebecca, and thanks for everybody who joined us today.
Thank you.
This is for you. I don't know. Sorry.
Excellent.
That's really fun.